Today, we're going to talk about one of the most serious charges anyone can face in the state of California. We're breaking down Penal Code 187. That's the law for murder. And look, understanding how this all works isn't just for lawyers. You really need to grasp what's at stake from the moment the system gets put into motion.
Picture this. An arrest is made for a charge this severe. For the family, it feels like the entire world just grinds to a halt. They're thrown into this state of total shock, just trying to process a new reality that feels like an absolute nightmare.
And in those first critical 48 hours, a tidal wave of questions just hits you all at once. So we're going to walk through exactly what those questions are and why getting the right answers, and getting them fast, is so incredibly important.
To really understand what's happening, you have to start with the charge itself. So, what exactly is Penal Code 187?
Okay, so here's the official language, right from the law itself. The law is incredibly specific. It's not just that a death occurred. The key phrase here, the part that literally defines the entire case, is that last bit, with malice aforethought.
So what does malice aforethought actually mean? It's not just some fancy legal term. It's the absolute core of the prosecution's case. It's all about the alleged mental state of the person accused. Prosecutors have to prove there was either a direct intent to kill or an extreme, reckless disregard for another person's life.
And this is where that mental state is just so critical. The presence of malice aforethought is basically the bright line in the sand that separates a murder charge from something lesser, like manslaughter. And that one single distinction, it changes everything, from the possible sentence all the way down to whether getting out on bail is even on the table. So all this legal theory, it doesn't stay in a textbook for very long. For families, it becomes a real-world crisis, like immediately. In those first 48 hours, everything boils down to a series of urgent practical questions.
The very first question is always the most immediate one. It's just a logistical scramble, a frantic search to simply find out where your loved one is inside the justice system.
And as soon as you figure that out, the next question hits you. When's the first court date? That's the arraignment, and that's when the official clock on the court process really starts ticking. But all of that leads to the one question that just looms over everything else in these early hours. Is it even possible to get them out on bail?
And that question takes us right into the incredibly complex world of bail for a PC 187 charge in California, where, let me tell you, the answer is very rarely simple.
Okay, so as a starting point, the California Constitution does establish a general right for people to be released on bail while they're waiting for their case to be heard. That's the foundational principle. But, and you knew there was a but coming, right? That right is not absolute. There are very specific and very serious exceptions written directly into the Constitution itself. So what are those exceptions? Let's break down the legal framework that allows a judge to look at a murder case and flat out deny bail completely.
The Constitution basically carves out two huge exceptions. First, for capital crimes, we're talking about cases where the death penalty could be on the table. And second, for certain felony offenses that involve violence, as long as the court finds there's a good chance it happened and that public safety would be at risk.
And if you want to see how this plays out in the real world, just look at this. This is right from Sacramento County's official bail schedule. For PC 187 murder, the presumptive amount is just listed as no bail. That's it. That's the default starting point in so many counties across the state.
Now, even in a situation where bail isn't automatically denied, a judge is going to be looking at all of these factors. I mean, given the sheer gravity of a murder charge, the concerns about community safety, and the risk that the person might flee, it often leads courts to set bail at an incredibly high and often totally unattainable amount.
So, with the stakes this high and the rules this complicated, the most important question really becomes, what happens now? And, maybe more to the point, how can a family navigate this without accidentally making a terrible situation even worse?
Okay, here are 4 absolutely critical rules. 1. Assume every single jail phone call is being recorded. Don't discuss the case. 2. Do not try to contact or influence witnesses. That can lead to brand new criminal charges. 3. Missing a court date is a guaranteed disaster. Don't do it. And 4, maybe the most important of all, do not wait to consult with a qualified defense attorney. Time is not on your side.
And it's so important to understand that this is just the beginning of a long, methodical process. After that first arraignment and the bail hearings, you're moving into protective orders, a massive review of all the evidence, and then intense preparation for a potential trial. That initial shock gives way to a long journey through the legal system.
In the end, every single decision in these early stages, it all comes down to this fundamental tension.
It's a collision between the constitutional rights of an individual and the court's duty to protect the public. And that forces a judge to make one of the most difficult and most consequential decisions in our entire legal system.